All right, this is a highly anticipated panel on Gen AI and IP. We're continuing with our next session, which will be moderated by our very own Professor Lemley. This is how he looks when he's not wearing his Jedi outfit.
I have to say, of all the uses of AI that could be made, a picture of me in a Jedi outfit seems particularly useless because you can find actual pictures of me in a Jedi outfit wielding a lightsaber. You don't need AI for that.
Anyway, so please come on in. And Professor Lemley is, of course, the faculty director of our program in Law Science and Technology. He's my boss here at the law school, so I have to be my best behavior here today. But yeah, he's not only one of the most published and cited author in IP, but in all of legal academia. And he's also a legal tech innovator. He created a legal tech project here several years ago, which became a startup, Lex Mach, that we all know, Lex Machina. And he will be running this Gen AI and IP panel here for us today. So please join me in welcoming our panel, and over to you, Mark.
All right, thanks everybody. So I want to ask the panelists to self-introduce in a minute, but this panel is a little different than everything else at the conference. We're going to talk about the law of AI rather than AI for law. And in part that's because it's kind of an interesting question, but in part because I think it's a question that is going to determine whether we have things like ChatGPT and other tools that can be used to these things, who owns them, who controls them, and how they work. And so a lot of the sort of legal issues that are going on right now, I think, are going to be significantly impacting the way AI develops and how it can be used or not used for law. So I am, as Roland said, Mark Lemley here at the law school. I will note that I am also a practicing lawyer at Lex Lumina, right, where I am litigating some of the cases that we are going to talk about, and we'll mention that as relevant. And let me ask, just going down the line, Angela to self-introduce.
Hi, everyone. I'm Angela Dunning. I'm a litigation partner at Cleary, based just down the street in Palo Alto. I've been practicing copyright and trademark, false advertising, write-up publicity cases for the better part of about a quarter century now here in the Valley. I also teach trademark law at a little law school across the bay that won't be mentioned in this environment. But I, like Mark, am litigating several of the copyright class action lawsuits that have been directed to the development, training, and output of generative AI tools. And I'm excited to be here to talk to you about that with my esteemed co-panelists.
Hi, I'm Max Sills. I'm the General Counsel of Midjourney, and I also run Open Advisory Services, which is a advisory practice for AI startups.
I'm Danielle Van Leer. Until about a month ago, I was a Senior Assistant GC for Contracts and Compliance at SAG-AFTRA, where I worked on AI and performer rights issues, name, image, likeness rights, rights of publicity, IP, privacy, all kinds of stuff. Whatever kind of didn't fit into the collective bargaining hopper fell in my area. Now I'm trying to figure out what I want to be when I grow up because I needed a change after the strike.
I'm Paul Goldstein. I've been on the faculty here since 1975, before some of you were born, and teaching principally copyright and generally around intellectual property, but mostly copyright and international and comparative copyright. Like Angela, like Mark, I am involved in some of the litigation that surrounds training, AI training as well.
Great. So I want to start with that set of litigation. There are, at my last count, 20 lawsuits going on in the United States, as well as several in other countries. And most of those lawsuits are focused right now, at least, on the sort of early stage creation of generative AI, the training, the building and use of a data set to train generative AI. Those data sets, of course, take enormous amounts of content to try to learn how language works, to try to learn concepts and image relationships. And because almost everything in the world is copyrighted in the modern era, almost everything that goes into a training data set is copyrighted. There are some notable exceptions, particularly in law, that we'll talk about. So where are we with the sort of fundamental question, right? Is it even legal to train a generative AI database? Angela?
Well, I'd love to declare that it is and have that be the end of it. But I think that we've got a little ways to go. So as Mark said, there are an awful lot of lawsuits. To date, very few of them have actually put the question to the court yet directly with respect to whether the training of an AI model constitutes fair use in connection with the making of copies for purposes of training. That issue will likely be the decisive factor in most of these cases, but we're a ways from getting a ruling. I would just highlight a couple of cases that are out in front. One is the case filed by music publishers against Anthropic, in which a preliminary injunction has been sought to block the further future training of Anthropic's Claude model on content owned by those plaintiffs. And in that case, the fair use question has been briefed in connection with the inquiry into whether plaintiffs are likely to succeed on the merits of their claim, which is a key factor in determining whether injunctive relief should be granted. And there are arguments that have been put in both ways on why the training on that content is fair or not, but there is not yet a ruling. And then I would also just point the room to the case that was filed by former Arkansas Governor Mike Huckabee among a class of writers in the Southern District of New York. That case originally was filed against a number of parties. All have been transferred out or dismissed except Bloomberg. And in Bloomberg's motion to dismiss, which is not yet fully briefed, they have sought dismissal at the pleading stage on fair use grounds, arguing that the tool they developed has never been commercially released, has never been used by anyone, hasn't generated any revenue. It was a research tool and a research tool deployed by a news organization, and so therefore on the papers very squarely within what fair use was intended to protect. So we're watching those cases, and it'll be some time before the fair use issues properly bubble up in the other cases that we're working on.
Yeah, and so just to note on the procedure there, right, I mean, that's because these cases are all at the motion to dismiss stage. Fair use is a defense, so it's not part of the pleadings, so you got to wait until the case is at issue. What we've seen, I think, in the cases is the whittling out of a lot of sort of ancillary theories of liability, right? So the courts have pretty, across the board, rejected claims that you are violating Section 1202 of the Digital Millennium Copyright Act by removing copyright management information in the training data set. They have, across the board, rejected the theory that the model itself is somehow a derivative work of all of the billions of works that went into training. training it. Some of the state law cases have gone away. So let's talk about the sort of heart of the fair use question, right? Is this, I mean, there is a lot of copying going on here, right? I mean, these models are built on a database, right, that trains maybe on Common Crawl, maybe on the Lion image database, right, but that are billions of different copyrighted works that, at least in the outset, right, in their entirety go into the database. Is that fair use? Why? Or why not? And Angela, you're welcome to jump in, but anybody's welcome to jump in with thoughts on this.
I'll start us off. I think fundamentally it has to be. What we as human beings have done from the dawn of time is ingested what knowledge exists in the world through the reading of books, the viewing of art, the general perception of language, and all forms of learning. We take that information, we then think on it, iterate on it in our minds, and produce new content. Obviously, if the content we produce is substantially similar in protected expression to somebody else's book or somebody else's artwork, then that may raise a real copyright concern. But the learning aspect is not just permissible. That's the whole point of the Copyright Act. That's the whole point of the constitutional provision that guarantees this limited copyright monopoly for purposes of ensuring that there is a promotion of the development of the arts and sciences. We want information in the form of literature, text, data, music, art, to be made available to all so that it can be learned from and developed further. And at the training stage, when you're talking about an AI model, you're talking about the making of copies, not so those copies can then be reproduced, which may raise issues, but so that you can take the information from those copies, whether it's art or literature or a Reddit post, figure out how language works, figure out what a cat is from its spatial dimensions, so that the AI can produce new content the same way that humans can.
Maybe just to add, I completely agree. Just to add to that, I think it's a good time to just check in on how we're feeling. Because I think that people are overloading copyright with a lot of feelings that we have around AI. So one issue that's going on is we're having another period of industrialization and automation. And people are upset because it seems like the monetary gains of that are accruing to a small amount of people. That's a separate question from what is current copyright law. There's also the idea of what do we want copyright law to be? So just to underline the point Angela was making, I think if you feel upset and you want money, it makes sense to advance the theory that you own a property interest in something. But the whole reason we gave people those property interests was to advance culture, advance society. And I think we might be at a point where we're forgetting the merger doctrine, forgetting the idea expression dichotomy, because we're confusing feelings of upset about the economic gains of automation with why we have this other law over here. So I kind of think that asking whether under current law is it fair is a boring question with a boring answer. It's yes, clearly. So I think we should be prepping ourselves for, like, what do we really want society, what direction do we want society to move into? We probably want society to maximize creative expression rather than let everyone assert a property interest over every idea they have.
All right, I'm going to disagree, for the feelings perspective, one thing I didn't mention is that I'm a screenwriter and photographer on the side. So I do have an interest on kind of on all sides. I do use, ChatGPT, for instance, in kind of ideating things, just trying to help break through writer's block. One of the guys I play D&D with uses Midjourney all the time to create really cool photos. But, there's the flip side of that is, one, it's like where the training data is coming from. I mean, these are like, a lot of this training data is coming from being harvested off the internet that people didn't necessarily, anticipate it would be used, and maybe they would have kept their IP private if they, if that was the case. I mean, certainly I have photographs that I wouldn't have posted publicly if I knew that that was going to happen. I'm not even thrilled that I have photos up on Getty, iStock, and Shutterstock. I'm not thrilled that they licensed my photos for training data. But I think I think there is it depends context here too, because it depends on the particular algorithm, right? I mean, if you look at, say, going back to the face swap videos, where they are literally taking clips from films and repurposing those, the output of that, is that training data fair use when the purpose is to reproduce that exact clip or those exact people? I think this is something that, I am a proponent of very strong copyright, but I also have friends that, like I said, have used Midjourney for stuff. I played around with it once to create my D&D character picture, my little avatar. So, I think there's a middle ground here that we're not finding it right now because these are all shaking out. Everything is at the far ends of the extreme. We're not seeing many middle ground positions right now. But I do think it depends on the intent behind the training in large part when you start looking at the 4 factors. And it does depend on, I don't know that everybody here even knows are there folks who don't know the US 4 factors of fair use or 4+ factors?
I'm sure the answer to that is yes. This is not a copyright crowd.
So there's, under US copyright law, there's the defense, of fair use entails balancing 4 factors, but there's some question, depending who you ask, if it's exclusively 4 factors, if it's more. I'm on the side that advocates that it is more than just the 4 factors, and I always screw them up when I'm just speaking off the cuff, but it's the nature and purpose of the use. Like, so are you using it for profit purposes? So, are they training the algorithm to make money? The type of work that's being trained, and that can be whether it's a creative work or a factual work, that gets to the idea-expression dichotomy. The amount used, essentially, God, like I said, I always screw it up when I'm thinking off the cuff here. The amount of the work that you're using, are you training it on the whole book, the whole movie, or are you training it on snippets? And also on the effect on the market for that work. So if, and that can include taking away licensing revenue. So we do have to keep all that in mind. I mean, that was intended to balance, the common law approach to limiting copyright. So I think, not to mention when you start looking internationally, you get into a whole other mess where the Berne Convention has, which most major countries are signatories to, have more restrictions. And I think we're starting to see some interesting things happen internationally. I believe Japan is allowing training data, and the EU is adopting an opt-out or notice an opt-out process. So, this is, I think we can't look at it just with a US lens. We need to also look at it in the context of international.
Yeah, just building on Max's observation about feelings and Danielle's earlier beginning points, I think there are feelings in conflict here. On the one side, you have the feeling that we should be advancing research. The Constitution authorizes copyright to promote the progress of science and the useful arts, and certainly that's what training is doing. On the other hand, there is a feeling, certainly in the creative community, of what my colleague in the political science department has characterized in this context as a need for reparation. And it's interesting to take the reparation discussion and plant it squarely in the consciousness of people who feel that they've been ripped off, and whatever the technicalities of the law may be, deserve to be compensated in some way. I think that's the feelings that are in conflict. On the technicalities of fair use, Mark said, well, there's just a lot of stuff that we're copying. The 20 million books that Google digitized for the Google Books project was also a lot of copying, and was held to be fair use. I think when the fair use question is addressed in the ongoing litigation, The question will be, does the rule of the Google Books case from the Second Circuit apply here? Most of the litigation is in the Ninth Circuit, although there is some in the Second. And I imagine that what courts might have a close eye on is that the Second Circuit decision in Google Books turned on the notion of transformative use. The opinion was written by a judge who invented transformative use. And transformative use has come under subsequent review in the Warhol case, a quite different context, but it leads to some uncertainty about what does transformative use mean today, post-Warhol, or outside the Second Circuit.
Yeah, so I'd love to just build on a couple of points that were made, and Danielle and I have consensus on a number of things we typically find, actually. I mean, I think it's really important in setting the stage that we distinguish between the outputs of these models and the act of training, right? So again, any particular output that is generated from a model, if you put that up against an original work on which it was trained, or any copyrighted work for that matter, and it is substantially similar in protected expression and copied from the original, there may very well be a copyright problem.
And we're going to turn to that issue next.
Yeah, so I'll skip that. That's a contextual analysis of that particular output. What we're talking about in this question is just the act of training an AI tool to be able to generate language or to be able to generate images of any kind, right? If I want to create an image of a cat on a surfboard in Venezuela, that image probably doesn't exist anywhere. It's not infringing anybody's copyright, but without a tool that's been trained on lots and lots and lots of images, there's no way of doing that. So first, setting the stage there, I think we're talking just about training. Then I think it's important to put in context the concept generally of fair use and this idea-expression dichotomy. So the idea-expression dichotomy is just the basic rule that nobody can own an idea. Nobody can own a concept. Nobody can own information. Why not? Because we want everybody to be able to use those ideas and concepts and information to create new works, to write about them, to expand knowledge. So what we protect under copyright law is just the particular expression of that idea, the actual words used, the actual image created, the particular notes and rhythms that create a song. And so separating those two things is important because, again, everybody is free to take the idea. The Supreme Court has said absolutely, definitively, over and over, you are allowed to use the ideas and concepts from other people's work. That's what all knowledge is based on. So then style comes up, right? In the context of these cases, there are artists and writers who say, you're taking my style, but style's an idea. Nobody owns a style either. I can go to a museum and do my darndest to emulate Picasso's style. Now, I'll never be as good as Picasso. I may not be able to compete with him, but if I want to make 1,000 works in the style of Picasso, so long as I'm not taking his expression, copyright law permits that. And so in the context of training, what we're talking about is ingesting copies of works so that you can take information from those works about how language works, syntax, structure, how often words appear next to other words. This kind of information is arguably not even protected by copyright. And if what you're doing is taking that for the purposes of creating a completely new ability to generate new language and content, I would argue that is quintessentially transformative and exactly what the courts have held, including in the Google Books case, is permitted.
Right.
Go ahead.
Yeah, sorry, Mark. That's why I kind of said that we need to look also at the intent, right? Because I think if you were to take the scripts from all the Star Wars movies, train them to train an AI with the purpose of creating, I mean, you know, the same person creating or even just a company doing it, training an AI with all the Star Wars scripts for the purpose of creating Star Wars content, I think, you start getting to that intent, and I think you do obviate the fair use. So I do think that is going to potentially.
So this, both of these comments to me sort of get to the problem that is actually really hard to get people to focus on the distinction between the training and the output, right? So to me, right, if I decide to train only on Star Wars content, I don't think there's anything inherently problematic about that, except that it's almost certainly going to give you output that is substantially similar to Star Wars content. And if that's what I'm going to do, then I think we're going to be in a different and more challenging problem, right?
But can I just add one more thing? I'm sorry, Mark. Even the creation of identical works, even with that intent, that doesn't mean that it isn't fair use. Every time I go to photocopy something, I'm making an identical work. But if I'm doing that for purposes of scholarship, research, teaching, criticism, that may very well be fair. If I'm a brand owner, I may very well want to upload my content for purposes.
But again, we are wandering past training to content. I want to talk about that, but I want to close the loop on training, right? But the very fact that it is hard to separate these two, I think, is really important, right? Because this is what we're seeing happen in the lawsuits, right? Why are people upset about training? Maybe they're upset about training because they sort of conceptually don't like the idea that a machine might learn from their work, even if the machine is going to produce cats surfing in Venezuela, right? That has nothing to do with their work. That's a kind of weird objection, though, right? And when you get down to it, I think the objections mostly end up turning out to be, I'm afraid, there are two forms, right? One is, I'm afraid that the output will be too similar, right? That you will, in fact, sort of end up copying my work in the output. And that's an issue we're going to turn to in a minute, all right? Or the objection is, right, I'm afraid of competition from something that isn't infringing my work, right? And that's an objection, and it goes a little bit to Max's point, right? But it's not an objection copyright law cares about. So let me just sort of close the loop on training with two points to make, right? One is the reason that the lawsuits so far are mostly focused on training and not output is that training is an existential question for AI. It's an existential question for AI because of the way we have structured copyright's remedies regime. Right? Copyright has a statutory damages provision. So for every registered work, if you show infringement, you can get not just the actual harm you suffered, you can get a minimum of $750 per work and a maximum of $150,000 per work, depending on intent. If in fact training on 2 billion images is an act of infringement of all of those 2 billion images, then even assuming we pick the minimum threshold, we don't necessarily, we pick the minimum statutory damages that we are required by law to give, right, we're at $1.5 trillion in damages. Plaintiffs' class actions lawyers can do that math, right? And $1.5 trillion in damages sounds pretty good. Even if you're not going to get $1.5 trillion, maybe there's a settlement, maybe there's a lot of money to be had here. And so rather than hey, sometimes occasionally there is output that's substantially similar and that's infringing, we want the big hit, right? We want to say the whole thing is infringing and we are entitled to damages for all of that. Whether that's true, of course, depends a little bit on the issue we've also talked about, right, which is transformative use, but it also depends on another question, the fourth factor of the fair use, right, which is the market effect. Now, traditionally, we think of the market effect is my work substituting for yours, right? Are people buying my copy of this song rather than your copy of this song? If so, that's unlikely to be a fair use. But as Paul previously mentioned, right, one of the things we think about in market effect is also the possibility of a licensing market. And so one of the things that I think is an unsettled question in the fair use inquiry is, can we see a market for licensing training data? Is this a feasible thing? And Paul, I'd love to hear your thoughts on sort of, is the world going to end up not with lawsuits and statutory damages, but with a kind of like global license, compulsory or otherwise?
I think the answer to that, Mark, is yes, but it's a highly qualified yes. I think that however the current raft of lawsuits resolve themselves, there is going to be licensing going forward. There's at least a very substantial chance that there will be, in part because of this instinct about reparation. but also in part stuff that is happening in Europe right now, and Danielle properly alluded to foreign activities as being very important. And I'll get to that as the fourth of my licensing possibilities. But there are 4 ways in which licensing of training activities, exclusively training activities, could go forward. One is the traditional negotiated 2-party license. There is some precedent for that. I think one of the early ones was OpenAI's license with the Associated Press. And there are others going forward. The problem with that is scalability and transaction costs. There's just too many licenses to be negotiated. There is a variable factor there, though. There was a really ill-conceived bill introduced in the Congress this week by Congressman Schiff that would impose a duty of transparency on platforms that are doing training and require them to list all copyrighted works that they've trained on. It's a very short bill, but it is just totally inconceived. And among other things, the sanction for noncompliance is a one-time fine of $5,000, which well, let's put that to the side. I think individual negotiated licensing is probably a non-starter. The second and third are collective licensing and compulsory licensing, both topics that the Copyright Office asked for input on in their current notice and inquiry that will be getting a report from them, I think, starting in a couple of months, and there'll be a series of reports. The responses to that were collective licensing. There was some support among authors groups particularly, and that is, if you think of ASCAP, BMI, and CSAC in the music area, of having collective licensing by collective management organizations, CMOs, it got some support. The problem in the US with collective licensing as a solution to transaction costs is that the US has 4 CMOs for musical performance rights and virtually no CMOs for all the other kind of content that is subject to copyright. You contrast that with Europe and Latin America and even Asia, where there is a single CMO for each, at least one, but typically one CMO for each area, for photography, for visual arts generally, for writing. And so the thought of getting those collecting organizations in place in the US is certainly problematic. There was less support for compulsory licensing. And for good reason. The major proponents of it were student groups, one from Hawaii, the University of Hawaii, and the other from Brooklyn Law School. The 2 student groups liked compulsory licensing. Nobody else seemed to care for it. And again, for good reason. Compulsory licenses are frowned upon. As Danielle alluded to, there is the Berne Convention, which in Article 9.2 puts limits on countries' ability to subject normal free market licenses to licensing. The fourth kind of licensing, and the one that I think is most likely to come into place, and to do so within the next 2 years, is automated licensing. Metadata attached to individual works that will communicate with the platform prior to training saying, I don't want to be copied, I will agree to be copied, but I need to be compensated in this amount, or go ahead and copy, but give me this other consideration. I'm sure many of you recognize that as Content ID, which makes YouTube possible within a world of safe harbors, where otherwise they're subject to notice and takedown. I think that's likely for a couple of reasons. It has precedent. The content ID precedent. It's an elegant, low-cost solution, and probably the most compelling reason is we're not going to have any choice on the matter. Some of you may be familiar with Article 4.3 of the Digital Single Market Copyright Directive that carves out an exception for training, but says in the event that a rights holder gives notice that it objects to the training, that notice must be honored. Well, that Article 4.3, an opt-out provision, applies only to copying training going on in Europe in the individual countries under the principle of territoriality. What's happened more recently, last month, was the adoption in the European Union of the AI Act, which in Article 53C makes the Article 4.3 obligation an operational obligation across the board, not only for training that occurs within the countries of the European Union, but that occurs anywhere. Let me just raise real quick, there's an obligation among nations to put in place a policy to comply with Union copyright law, Article 4.3, and in particular to identify and comply with, including through state-of-the-art technology, a reservation of rights expressed pursuant to Article 4.3. Now that is going to apply extraterritorially. It's going to apply to any platform that does its training anywhere, so long as they're doing business in the European Union. It's akin in that respect to the GDPR, General Data Protection Regulation, which similarly imposes an extraterritorial obligation respecting data privacy on countries outside the European Union if they are doing business in the European Union, and that has had the effect among American companies that are in that business of conforming their conduct, in part because of a vacuum of privacy law under US law, but in part because they need to do business in the European Union. This is the so-called Brussels effect, and we will find ourselves, I believe, when the AI Act comes into force, it's about 2 years and a couple of months from now, in a position where that kind of compliance will be required.
And worth noting, there is no fair use doctrine in Europe.
There is no fair use doctrine in Europe.
So I want to say on the licensing issue, I mean, I am troubled by this, right? Because I think the economics are fundamentally different than the economics of the places where licensing is worked, right? We have licensing for satellite broadcasts of transmissions, right? We have licensing for kind of covers of songs, right? And that works because the thing I'm using is one or maybe a couple of individual copyrighted works, and so we know who the people we want to pay are and so forth. But I struggle with sort of what it would mean to say we'll pay a fee for training on 2 billion images selected from the Lion database. So Stability AI, right? The whole company's worth $2 billion, maybe less right now after recent developments, right? But right, even if we said, all right, you know what, we're going to take half of the entire value of the company and pay it in compulsory license fees to copyright owners, everybody gets 50 cents. I don't think when people think about like compulsory licensing, they think, I want my 50 cents, right? That's not 50 cents per use, that's 50 cents, period, for training, right? And so what I worry about is that if in fact we're in a world that Paul's talking about, right, what we're going to see is a bunch of people who say, sure, I'll license my thing to be trained for $5,000, right? Or maybe $500, right? And that's just impractical, right? No one can build a large training data set. There may be specialized ones, right? It may be that you want to train on a few particular things. Music might be a great example of where people would be willing to pay a certain amount of money, right, to train a music data set, although that's often going to be because we want to generate things that that seem very similar to your song, and that might not be very popular. So I worry a little bit that sort of the practical effect of this is not going to be, we'll get a licensing scheme that works. I just don't think the economics work for it. We'll get a bunch of people who say, right, sure, I'll do it for money, and then we just opt out completely. Right, that the result will have to be we can't train on anyone who doesn't give it to us for free, or we can't train unless we happen to be Google or some other company that has gotten the ability to collect this information for other purposes and has put somewhere in their terms and conditions that we can use this for whatever purpose we want.
If my royalty statements from my photos is any indication, it's about 1/100th of a cent for a photograph, give or take, I think is what, I can't remember if it was 1,000th of a cent or 100th of a cent,
Yep.
So.
Don't spend it all in one place.
I know, it's, I think the total for the number of photos I have up in that library for that training data was about a penny.
Mark, two responses, Mark. One is you started off talking about compulsory licensing, which is going to be a non-starter. But notwithstanding that, bear in mind, we do have a compulsory license that was implemented in the Music Modernization Act a couple of years ago that creates a blanket license for making copies of all music subject to a rate set by some administrators in Washington. So we do have that possibility for dealing with millions of content. It's a so-called, it's sort of a hybrid. It's a compulsory blanket license. And so everybody's work comes under it. Under the second observation you made, which I think relates more to content ID, which I think is right, is going to be the path going forward, a content ID-like system. The situation there is, sure, there can be plenty of people who say, I want $5,000, and they're going to get rejected. And pretty quickly, the market is going to drop down to the 0.5 cents per use or per training use, whatever it is, because that's the most you're going to be paid. It's like a Spotify royalty, which is close to zero. So I think the market is going to drive down those demands. I'm not saying $5,000 is unreasonable. What I'm saying is the market is not going to sustain it.
All right, so people wanted earlier to talk about output infringement, and I think we want to talk about shift from training to output infringement. So I noted earlier that training is an existential question, right, because it's sort of the potential amounts of money here if you can't do it legally are enormous. Output infringement, by contrast, is a more specific and targeted problem, right? The vast majority of things generated by generative AI are not substantially similar to any copyrighted work. Right? They are not infringing, they are not a problem. But sometimes it happens, right? Why does it happen? One reason it happens is what we call in computer science the deduplication problem, right? So it's not that generative AI decided to copy your particular text from this particular instance, right? It's that it turns out there are 10 or 15,000 copies of this particular image or of the Harry Potter books floating around on the internet that got into the training data set. And so when you ask it a specific enough prompt, right, you get a result that is an amalgam of the closest universe of things, and all of those closest universe of things turn out to be the same image, right? And so the result looks like the same image or looks like the same text. Second reason it might happen is sort of deliberate prompting of infringement. Right, so when I work with the folks in the computer science department, right, if you ask ChatGPT to give you a story about kids who go to a wizarding school in Britain, it doesn't give you Harry Potter or anything similar to Harry Potter. But if you ask it to give you a story about kids who go to a wizarding school in Britain that begins with and then feed it into the prompt, the first paragraph of Harry Potter, well, then it actually does spit out something relatively close to the first chapter because it recognizes that that particular unique combination of words is likely to occur only in specific contexts along with other combinations of words. And we see some examples of the prompting infringement problem in the New York Times lawsuit, right? Where the New York Times says, hey, look, OpenAI spat out our news story. And if you go look behind the scenes at the exhibits, right, it turns out that OpenAI spat out our news story when we said, give us a New York Times story with this title that begins with the first 9 paragraphs. And, you know, that is an act of infringement, I think, all right, although the question of who's responsible for it, I think, is an interesting one. And then there's another set of problems which I think of as the Baby Yoda problem, right? And that is, there may just be concepts, right, that the software recognizes as a concept in the same way it recognizes coffee cup or cat to generate an image. There are enough Baby Yodas out there in the world, and they all look similar enough that if you ask it, give me Baby Yoda, it knows what a Baby Yoda is, and it will give you a very realistic looking image of something that turns out is copyrighted. So these are, I think, Angela said earlier, this is a potential problem, right? I mean, even if you think training's fair use, generating an image of Baby Yoda seems much less likely to be fair use. What do we do about it? Yeah, Max, go.
I think we're pattern matching to stuff we saw before. And that's, I mean, this is a legal audience. Yeah, that's our bread and butter. But I think that I just want to see if we can forecast a year or two in the future about what these outputs are. What is AI for at all? Why do we have, people are still trying to figure that out. But I want to relate a very short story. Someone emailed me and things were getting a little tense. They sent me a winky face emoji. And that was like a hit of dopamine. I was like, oh, okay, maybe things are okay. It wasn't being conveyed in the language, but in that emoji, there was something being communicated that couldn't before. And at least what we're trying to do, and I think lots of procedural generation companies are trying to do, we're trying to expand the way that people can make outputs at all. Expand the vocabulary that we want you to be able to communicate new things with each other. And so from that perspective, I think like we're getting very stuck just pattern matching to the world we see. And it's like caveman thoughts, like, money there. Saw it. I made it. I want it. Give me money. Or also like, I'm scared because new. How do I do new? What is new for? But I think like very soon, generative AI is going to be stuck to human culture. It's going to be like language. We're not going to be able to communicate with each other without it intermediating. So I think it's really important to think now what do we want the laws to be? Do we want copyright law to restrict how we think when we start using it as such an inseparable tool in our thinking? Do we want copyright law to restrict how we communicate with the people we love?
I think we're going to see it go, taking Max's challenge looking a year or two ahead, I think we're going to see some of the litigation go some of the same ways that we saw with the file sharing cases. And I do think, maybe the it's a Grokster case, the inducement liability might come into play. To the example I gave earlier about if you're training a AI algorithm specifically for a specific purpose, so you're creating one to training it on the Star Wars universe to create Star Wars content and, to encourage people to create Star Wars content that is infringing, I think we're going to see, something along the lines of an inducement liability on something like that. I think it'll be interesting to see with the Midjourney type and OpenAI, ChatGPT stuff where it's a more general algorithm, more general purpose algorithm. It's going to be interesting to see where those go. But I do think in some cases, we're going to see an inducement form of liability come into play.
So I'll just add on to that a few things. And this is the point that maybe I started to make on the training question that was better suited here. So if you imagine a scenario in which a work is generated through an AI tool that is plainly incorporates the protected expression of a work, or is it identical copy? I mean, there are easier ways to do that than trying to intentionally engineer a prompt to deliver that. Again, back to our photocopier example. But assume that you are able to generate that. There are any number of perfectly valid and appropriate reasons you might want to do that. If I'm a brand owner that has a really fantastic logo, for instance, and I want to feed that into a tool to figure out and ideate around potential variations, ways that I might expand upon that, I have every right to do that, and it would return content that I own. If I want to ask a tool to produce some image for me that I want to use in an article to highlight, for instance, concerns over the creative content of someone, I'm allowed to use that for news reporting, even if in another context, with another intent, it might be infringing. So there is this desire, I think, as we have this conversation, to put everything in yes or no, black or white boxes, but it doesn't quite work that way. It's very contextual. There is no question that these tools can be misused for ill purposes, and the copyright law does not allow that. What can't be said is that the fact that these tools are capable of generating content that in certain instances will look very much like copyrighted content on which it is trained is necessarily improper. And I want to take us back to Warhol. So the professor mentioned that. In Warhol, you had Andy Warhol, who had been through a license entitled to make a silkscreen of a Lynn Goldsmith photograph of Prince. Now, he made more than one. He exceeded the scope of the license. He made 16. And later, when Prince died, and a magazine wanted to write an article about Prince, they went back to the Andy Warhol Foundation and found out that there were additional silkscreens and used one that hadn't been authorized. And the court found that's not okay. There was actually a licensing market for this work. In fact, that's how you got your hands on it in the first place. And you used it for the specific purpose that it had originally been licensed, right? You used the photograph of Prince to create a work for illustration of him in an article. What the court stopped short of saying is that the making of the work in and of itself, the other silkscreens that never appeared anywhere, was not fair. Because until those are deployed, until we know how they're being used, we don't know if it's fair or not. It's sort of a Heisenberg uncertainty principle, or, there is an element of, if the painting had been hung in a gallery, or if it had been used for educational purposes, that may very well have been a fair use. And the court said, we can't decide that here. We're not going to decide that here. We're going to decide on this particular use.
So I think it's right to say that this is, output infringement, unlike training infringement, which is a kind of existential question, is a fact-specific contextual question, right? What particular thing has been generated and who has generated it? Although I do think, to go to Daniel's point, one difference here between this and the internet cases, which may matter a lot for the AI companies, is it's not obvious that your liability is only for inducement, right? And so one of the questions we resolved early on in the internet was this sort of question of volition, right? If I ask a machine to give me something and it gives me something, who's making the copy? Who's the direct infringer, right? On the internet, right, we were happy to say that if I'm just hosting content that other people put up there, the fact that I sort of deliver it in an automated way doesn't make me the maker of the copy, it's the person who's asking for it. AI looks a little different though, right? Because I am generating a new thing in response to a prompt. I think there may be a line at which a specific enough prompt that is clearly designed to misuse the system might make the prompter and not the AI directly responsible for infringement. But I think there are going to be a bunch of things where a prompt generates some output that is infringing, but it is the AI itself that is making the thing, and therefore it's the AI itself that is the direct infringer. That matters, I think, because copyright is a strict liability offense. The fact that you didn't intend to do it, the fact that you sort of took efforts to try to prevent it from happening won't necessarily mean that you avoid liability. Max.
I guess I wonder who would do that. Like, I mean, if you want a direct image, you can just go find it on the internet. who is using generative AI tools to intentionally copy
Right.
works
So
that they've
plaintiff's lawyers is one answer, right? But that's a kind of a very small answer, right? I mean, look, most of those things have in fact been the plaintiff's lawyers in the cases. But it's a fair question, right? So my guess is it's not. It's a very bad copy machine. It's a very inefficient way to use as a copy machine. So I agree with that.
In contrast to the Grokster.
But what it's going to be, I think, is going to be more of the style cases. Right, it's going to be the sort of like, I want something that looks similar to, but not identical to this thing, and maybe it's too similar and maybe it's not. But that, again, is going to be a sort of case by
Well, it's
case.
also the derivative works more than the direct infringement, just to answer that
All
question.
right, so we have lots more things that I would love to talk about, but I also see people lining up at questions, and so maybe we should hear what you want to talk about. Pablo.
All right. So Professor Goldstein, the fair use question, which is sort of this existential issue, you mentioned sort of coming down to the transformation question and noted that there's fuzziness around that, which I think we would, not surprising given where that doctrine has to operate. But it occurs to me that back when you taught us copyright, if you said, we're now going to all go brainstorm, the most transformational use cases we can think of, like what is the most, almost a caricature of transforming something? Nobody could have come up with, I'm going to create 30,000 multidimensional vectors pointing randomly and then have them reorient themselves so that they can guess the next word of these texts. Like that would have been, and so even in a world where there's some fuzziness, what I don't understand is how is this anywhere close to a close call? And tell me what I'm missing, because it seems to me that like any fuzziness of the doctrine aside, we're so off the charts for transformation that then game over, no licensing, nothing, we just all go back to,
Yeah. As usual, Pablo, you're not far off the mark. You weren't in class and you weren't there. I didn't mean to say you weren't present in class. You were always present in class. Yeah. No, I think the way transformative use worked in the Google Books case was the use to which ultimately the copied works were put, the snippets from the copied works were put. And so I think transformative use here would, in looking at training activities, would say, to what use are these measurements, these tokens, effectively being put? And they're being put to a use that is totally transformative as compared to the material on which they were trained. So does that take care of it? Good.
And
okay.
I would just add to that, though, that part of, I wrote an amicus brief in the Warhol case, and there were a bunch of amicus, a huge number of amicus cases, briefs. And, I think one of the concerns that we had and that others have had was that the focus of fair use analysis has turned, is it transformative? Forgetting that there are 3 other factors, and even transformative is nowhere in the fair use language. So it's just been something that has become an easy way to just, it's transformative, so clearly it's fair use. But, and I believe, if I recall correctly from the opinion, the court said we have to analyze these all 4 factors. And I think they even did in the Oracle v. Google case, which also turned on one particular factor. But that's gotten lost in fair use jurisprudence, is that transformativeness is not the only determinant factor.
I wondered if you could comment on the acquisition of the training data, in particular terms of service on websites. Say I downloaded, millions of hours of YouTube videos, let's say, and then built a video generating system, as an example.
Yeah.
Just a random example?
Just a random example. And I didn't do this, but one may have done this somewhat.
So I think the answer is probably not a copyright problem per se, but quite potentially a sort of breach of contract, breach of terms of use problem, if in fact that's how you get it, right? Now, most of the databases, I think, most of the generalized ones, right, have used Common Crawl right, which respects the robots.txt header. So they said, we're going to go crawl the internet for the universe of things that have said, yes, please crawl me and index me in a technical system. I think probably many of the people who set robots.txt to yes didn't have generative AI in mind. They have, I want to appear in search engines in mind, and it might be that we, right, in the future start to distinguish those things, right? Or the Lion database, right, which is a sort of database of image categorizations that is in turn taken out of Common Crawl, right? That is an effort to sort of get around those problems. I don't think it gets around all of the copyright problems, in part because many of the people who put up information or data on a website and said, sure, please index me, might have illegally taken that information, right? The Books3 database might be an example of that. But I do think if you are going to a specific website to crawl that website and it does not have a robots.txt header that says no problem, you ought to be worried about that.
Hello. So my question is more about what would be the model for compensating the creators for the content, whether that is text, like a web page, a video, maybe uploaded on YouTube, or a photography work. So as industry and technology developed, it seems that people found ways how to compensate the creators. So for web, we can embed AdSense, and Google pays the web page creators for their work. For video, we have a YouTube kind of determining algorithmically how to pay YouTube creators, and Spotify is doing that for audio. My question: do you think there would be kind of emergence of maybe Spotify or YouTube or AdSense, some type of a technology that would be embedded in the content itself, that could help companies like Midjourney or OpenAI to actually compensate to those creators?
Paul, you want to take it first?
Yeah, I think it's going to be various. It's good, it's interesting that you use the example of Spotify, which is a smoothly functioning, not very low paying, but a smoothly functioning operation, which rests on a compulsory license. It's the digital phonorecord delivery compulsory license of Section 115. And that is basically what drives Spotify, and they have periodically to negotiate rates between them and the publishers with the Copyright Royalty Board. But that's one way to do it. Another way is the YouTube way. Interestingly, the legal infrastructure ultimately makes, whether it's a effectively negotiated license with Content ID or a compulsory license with Spotify, the legal infrastructure at the end of the day makes very little difference. It's the economic arrangements built on top of it that really count.
Angela, real quickly, and then I think maybe one more.
I just wanted to say it really depends, too, on whether you're suggesting that there should be some sort of licensing regime for outputs versus training. I mean, to Mark's point earlier, the only conceivable regime would involve some mechanism for a single training license fee. You cannot conceivably imagine that everybody who's taken a picture of a mountain somewhere where a platform has been trained on 2 million pictures of mountains suggests that an output that may have a mountain in it that looks nothing like those 2 million mountains would be entitled to any kind of compensation. That's never how copyright law was meant to work, and it would destroy the technology before it's had the ability to come into full fruition to solve all sorts of problems we haven't even talked about on this panel. I mean, there are amazing, as yet undiscovered reasons we need these technologies developed in drug discovery, disease pathways, solving traffic, solving climate, big questions, right? Not just cats on surfboards in Venezuela. And
I'm so going to Google that now, Angela. If I can just make one comment on the business models, because what we didn't get to, we were going to talk about was like the celebrity impersonation and digital avatars, digital replicas. There are a ton of companies out there trying to, and music actually also, trying to develop compensation and tracking models and different products to try to handle this licensing concept, but, so I think there is.
And that to me, right, that's going to work because it is specific to
Right,
an
right.
individual or a few individuals, right? If I want to use your image, right, then I ought to be paying you, right? I think it's much harder if it's everyone who's ever taken a picture of a mountain should get a billionth of a cent. All right, last question.
Yeah. Question regarding the current court cases. What is unique about them compared to some of the historical ones regarding, copyrighted data, IPs indexed by some of the search engines? We have seen so many cases. What the current cases makes different regarding usage of the data?
I mean, they're ongoing, so we don't know how they're going to come out. I mean, I think as Angela has kind of suggested, right, and Paul suggested in response to Pablo's question, if the question is, what does existing precedent say as to training, existing precedent lines up pretty strongly in favor of this is a very different purpose, it's a new technology, that's going to be a fair use. Things that might change it, right? A licensing market, right? If we thought there was a working licensing market and therefore you're depriving people of revenue, that can change the fourth factor and it could change the analysis. And techlash, right? We are in a moment of sort of like AI moral panic. And I think that affects judges. And it might well be that a legal decision that in a different technology and a different kind of psychological era would clearly have come out in favor of the tech company might come out differently because people are afraid of AI. That's not what should happen, but it might happen. And I think with that, we're going to have to stop. Thank you all.
Thank you for this terrific.